Depending on the circumstances surrounding allegations of wrongdoing, an agency may need to provide employees with a Garrity warning prior to questioning them. Let's take a look at the history of the Garrity warning and its appropriate application by local government employers. Garrity Rights protect public employees from being compelled to incriminate themselves during investigatory interviews conducted by their employer. This protection stems from the Fifth Amendment to the United States Constitution, which declares that the government cannot compel a person to be a witness against him or herself. The Garrity warning comes from a United States Supreme Court case involving police officers who were under investigation for allegedly fixing traffic tickets. Let's take a closer look at the historical context of the case. The officers were given a choice of either providing a statement to their employers, which may subject them to a criminal prosecution, or to forfeit their jobs. The Supreme Court held that any employee statements made to a public employer under these circumstances were coerced, and the Constitution prohibited their use in a subsequent criminal proceeding. For a public employee, the employer is the government itself. When questioned by their employer, they're being questioned by the government. Therefore, the Fifth Amendment applies to the interrogation or questioning if it's related to potentially criminal conduct. The Fifth Amendment protects individuals from being compelled to be a witness against themselves in criminal cases. Pleading the Fifth is a colloquial term for invoking the right that allows witnesses to decline to answer questions where the answers might incriminate them. Thus, the Garrity warning was established. If an agency forces an employee to answer questions in an investigative interview by threat of disciplinary action, it must inform the employee that statements and any resulting evidence cannot be used in any criminal proceedings against that employee. A Garrity warning should be used sparingly. The overuse of Garrity in discipline investigations is common and can result in unanticipated negative consequences for the agency and the public at large. Only if the agency is certain that compelling a statement is in its and the public's best interest, and adequate safeguards are in place for securing data, should the employee be presented with the choice of cooperating with an investigation or facing disciplinary action. So, before giving a Garrity, and assuming the risks of tainting future criminal proceedings should any self-incriminating statements be leaked in any way outside of the employment investigation, stop and ask yourself the following question. Does the investigation require a compelled or coerced statement? The answer is rarely yes. A safer course of action is to start by requesting the employee provide a voluntary statement. If the employee gives a voluntary statement, no Garrity is required, and the statement itself may be used in future criminal matters against the employee. An agency may simply ask if the employee is willing to provide a response to the allegations. Most employees will want to provide an explanation to the alleged misconduct. If the employee refuses, the agency is free to make a determination of the investigation based on the information gathered, or consider compelling a statement and providing a Garrity warning at that time. Finally, it is often best to allow any criminal proceeding to conclude before an employment investigation is initiated, since failure to keep the two separate can and will result in tainting of both with severe consequences. A worst-case scenario is that criminal charges must be dropped, not for lack of evidence, but for a procedural mishap.